recorded. There we go. And now I'm going to turn it over to you. If there are any questions, could you put them into the chat function, and then I'll be moderating, so I'll be able to pass them on to Beth. Thanks.
Hey, good afternoon, everybody. Thank you for asking me to present. Sorry that it's not in person yet. One day soon, hopefully, we'll be back to in-person presentations. The topic I'm presenting on today is civility. When Glenn and I were talking about what would be a good topic, civility is something that is impacting the profession, seems nationally, and also we're hearing from the American Bar Association in the United States that it's also an issue there. So that just seemed like a good update. And this isn't designed to be a finger wag at all. Really, it's just, what are we seeing? What are some of the cases? And what are some strategies that somebody who's on the receiving end of somebody who's maybe struggling with civility can employ to maybe make life a little bit less miserable? So that's the background. Excuse me, I'm happy to answer questions. Normally I'd answer them as we go, but I find that difficult over Zoom. So please put them in the chat and we'll work through them at the end. Could you move it to the next slide, please, Glenn? I hope you're able to see this. Calvin and Hobbes kind of became a little bit of a running theme through the presentation, maybe because my son was homesick as I was working on this presentation and he was reading Calvin and Hobbes. I don't know, but in any case, Calvin here seems to discuss how civility is boring, and I suppose it is. Maybe this sums it up. Lack of civility creates lots of drama, lots of painful drama, in fact, if you're on the receiving end of it. What I'm seeing from the lawyers who've been calling the practice advisors over the past 2 years, it's frankly terrible and regrettable and difficult. And if that's the alternative, I would work against Calvin and take boring. Next slide, please. So these are the topics that we're going to cover today. I'm not necessarily covering them in this order. This is really just a very general outline, so you have a sense of what some of the topics are and what's happening in the Law Society and also in the courts. There's a couple of cases come out of the courts. I mean, the big one, of course, being Groya. That's notable. So yeah, that's the rough outline. Next slide, please, Glenn. So as long as I've been practicing, I've been hearing concerns about lawyer civility. I remember being in my bar school class and instructors raising it then. We call it civility. The American Bar Association calls it professionalism. So if you hear me use that term a couple of times in the presentation, it is the same thing. As a practice advisor, I'm hearing from all corners of the profession. I'm hearing from the bench. I'm hearing from the CBA, who are hearing from lawyers. I'm hearing from lawyers directly. I'm hearing from students, and I'm hearing from staff about how bad it is right now. And it's not just lawyer on lawyer conflict. Of course, it's client to lawyer, so managing clients as well. And while the image on your screen is an image of lawyers fighting in person, a lot of what's happening right now, or has been happening, is happening virtually. It very much seems like the lack of physical immediacy, the lack of actual connection to people, is fueling people's disrespect, their lack of compassion, their lack of courtesy, just even the lack of basic norms and how we ought to treat people. It's almost like, well, if you're a talking head on a screen, maybe you don't have feelings, right? Which is not the case, of course. The Canadian bar isn't alone in seeing this trend. The American Bar Association describes a, quote, widely perceived accelerating decline in professionalism. Law societies generally don't regulate for civility alone. Sometimes it's included with additional citations. So even when a lawyer phones me and says, look, this other lawyer is treating me so badly, and you know, should I report this? Like, well, I suppose you could report it, but maybe that's something that would be managed in maybe practice management or early intervention, but it's not likely to be something that the Law Society would run up the flagpole on a conduct matter. They will lump it in with other citations if there's other problems happening. And with very notable exceptions, the courts generally don't address civility either. And I mean, I cite one case later in the presentation And the outcome in that case was surprising to me. I would have thought that the court would have addressed the lawyer directly, because the lawyer was the one responsible for the way the tone and tenor of the file, not the client. And this seemed to penalize the client instead. So if the courts aren't addressing it, the law societies aren't necessarily citing it, where does that leave us as a profession, as people who witness civility, as people who are on the receiving ends of lack of civility? And I think what is clear is that lawyers, we need to voluntarily set a higher standards for ourselves as professionals, to try to be aware of what's happening and what we're doing and how we're responding, and coming up with some strategies to maybe keep the tenor of the file down. Next slide, please, Glenn. So in terms of the substance of the substantive law or rules on civility, I want to start by considering our fundamental role as lawyers. What is it that we do? We are advocates. We advocate for others. We promote their interests, sometimes even fighting for those interests. We do that in the courtroom, certainly, but we also do it when we're negotiating deals at boardroom tables or before tribunals. So advocacy certainly is the realm of civil litigators or criminal defense lawyers or crown lawyers, but it's not only their realm, it's all of us. And advocacy is the basis of civility, as Rule 5.1-1 sets out. It's the foundational role of the lawyer's relationship to the administration of justice. And this rule requires fearlessness. I always think of courage in advocacy. Those two things really go together. It requires fearlessness because it requires a lawyer to advance every argument and take every question, ask every question, even the distasteful questions, if that is something that in the lawyer's reasoned opinion will advance the client's interests. The commentary to the code under this rule notes that maintaining dignity, decorum, and courtesy stays in the courtroom, but of course we know it's elsewhere too, isn't an empty formality, because unless order is maintained, rights cannot be protected. So it isn't one of those esoteric principles that has no practical consequence. It's very much something that impacts clients' interests. The code stipulates a high level of lawyer civility, and that means agreeing, of course, to reasonable requests and avoiding sharp practice. We get lots of calls from lawyers about, well, I think this lawyer's engaging in sharp practice, which is, somebody acting badly and with a lack of civility. Sharp practice has a very definite definition, which is taking advantage of an error. At its heart, that's a lack of advocacy and a lack of civility. So being civil does not mean that a lawyer isn't a resolute advocate. Being civil should not prejudice the client's case. So to summarize advocacy, it means raising every issue fearlessly. It means advancing every argument, asking every question, no matter how distasteful, if it will help the client's case. But that duty has to be lined up with the lawyer's duties to the court, to the profession, and to the public. So the obligations to the client don't override those other duties. And I think that's where, in that crack is where civility can bloom. So if I was asked to sum up advocacy in 2 words, the words I would choose are courage and respect. Next slide, please, Glenn. The Supreme Court notes, and this is the Groya decision, which I think most people are aware of. It's so rare that a matter reaches the courts, which is so defined in terms of professional obligations. And so to go all the way to the Supreme Court, of course, it started, the Groya decision, if you don't know, started as a law society regulatory matter that was judicially reviewed by the courts and made its way all the way to the Supreme Court. And there are relevant provisions, not just in the Supreme Court, relevant thoughts and holdings, not just in the Supreme Court's decision, but also in the Ontario Court of Appeals decision. The Supreme Court notes that the peaceful resolution of disputes doesn't mean that trials are tea parties. Of course, trials aren't tea parties. It's always hard. A lawyer's duty to act with civility doesn't exist in a vacuum, but in concert with all of those other professional obligations that constrain and compel a lawyer's behavior. The Supreme Court states, quote, care must be taken to ensure that free expression, resolute advocacy, and the right of the accused in criminal cases to make full answer and defense aren't sacrificed on the altar of civility. And this is where I think courage comes in, right? Because yes, you have to be civil, but you still have to be courageous to make those difficult arguments, to advance those difficult points. So it doesn't mean sort of the lion and a lamb. It doesn't mean being a lamb, right? Being civil. Next slide, please, Glenn. Different terminology is resolute or zealous. You hear about resolute advocacy. You heard in that quote from the Supreme Court the reference to resolute advocacy. And we hear zealous advocacy a lot as well. Our code in Canada, the Model Code, and also the Northwest Territories Code, stipulates resolute advocacy, not zealous advocacy. That's the American standard. Some lawyers and justices, including notably Justice Alice Woolley, who is an amazing ethicist, don't see a difference between the two. And with the greatest of respect for Justice Woolley, I do. I look at that screen even, that slide, and look at the different synonyms for zealous versus resolute and see the difference. In preparing for this presentation, I read an article by the American Bar Association aimed towards junior lawyers and students. And that article tries to dissect what being a zealous advocate means. That dissection requires a lot of backpedaling and parsing to say that, well, yes, the code says zealous, but advocacy has to be within the limits of the law, not the edge of it, which is where zealous is. And that despite the meaning of the word zealous, law isn't a zero-sum game that is, my client can only win if yours loses. And I think that's why there's a difference between resolute or zealous. I think our system is different from the American. Yes, we look to the American system for guidance on some principles and concepts, but I don't see zealous as being synonymous with resolute here. When you look to resolute advocacy, there isn't a need for the kind of parsing that I read in that article or explaining. By its own terms, resolute imports reasonableness, strong, but not fanatical. Next slide, please, Glenn. So civility doesn't just mean being nice or polite, or like I said, being a lamb. It's treating each other with courtesy. That's one key meaning. So that's the meaning on the left of the slide. The other meaning is much deeper, and it encapsulates lawyers' obligations of honesty and integrity. Civility is said to help ensure that lawyers uphold their duties as officers of the court and maintain and improve the standing of the administration of justice in the eyes of the public. So it's not just that, not getting into a scrap on a file where it disintegrates into personal insults. It's, perceiving or the perception of the profession and the administration of justice to our clients and to the public. And of course, we have social media, we have a very active media right now. So it does take on, these are things you're seeing in the news. So it takes on that additional layer of importance. And the code does contemplate a high level of lawyer civility. It's not just in one provision of the code, it's woven through the fabric of it. Next slide, please, Glenn. So the Supreme Court's definition of civility in Groya encapsulates both of those broader concepts in the previous slide. And then next slide, please, Glenn. The Court of Appeal in Groya articulated the test to assess whether a lawyer's uncivil behavior crosses the line into professional misconduct. And recall that this is the standard for legal regulators. This was judicial review, not trial. So the court is articulating the standard that regulators should apply. The test targets the type of conduct that can compromise trial fairness and diminish public confidence in the administration of justice. It allows for a proportionate balancing of the regulator's mandate to set and enforce standards of civility in the legal profession with the lawyer's right to free speech. And the lawyer's right to free speech, it's interesting, that comes up less in Canada. That is very much something that is raised in many different ethical issues in the United States. So as an example, when the American Bar Association amended their code of conduct for the harassment discrimination rules, they've received considerable pushback, and in fact, it's really stalled the amendments on the basis of free speech. Next slide, please, Glenn. So following Groya, what do we do now? To start, Groya is an unusual decision for a few reasons. I mean, just the fact that it made it to court and made it all the way to the Supreme Court is unusual. But one of the reasons is that we now have that ultimate authority of what civility is. It's the court's oversight of in the court's oversight of lawyer regulations. That's actually very helpful because we now have what could be considered an esoteric principle. Some might disagree with it being assessed as esoteric, but we really do have concrete guidance now. The court develops an approach to assess whether incivility amounts to professional misconduct. And that's the test that was on the previous screen. And it's a context-specific approach. For instance, in criminal law, resolute advocacy is needed to advance the accused's right to make full answer and defense. The context-specific approach is flexible to assess allegedly uncivil behavior arising from a diverse array of situations. The case also sets a reasonably precise benchmark that instructs lawyers as to the permissible bounds of ethical behavior and articulates that series of factors that ought generally to be considered in evaluating a lawyer's conduct. And it also allows the law societies to balance proportionately the lawyer's expressive freedom with its statutory mandate in any given case. So Groya is actually very helpful, yes, from a regulatory perspective, but I think as well from lawyers who are in the trenches practicing and knowing where is the line, right? It's a little less, it's maybe a bit more of a bright line and a little less of a line in the sand following the Groya decision. Next slide, please, Glenn. So as you can see, and we've already considered Rule 5.1-1 of the code, civility is woven into the fabric of the code. It's an all-encompassing principle, which is addressed and required by more than one rule. Disrespectful behavior is misconduct. Rules 5.1-5 and 7.2-1 require lawyers to treat the tribunal, and tribunal, of course, is broader than the court. It encapsulates administrative tribunals as well. So the tribunal and all with whom the lawyer has dealings has to be treated with courtesy, civility, good faith, and respect. The commentary to Rule 5.1-1, which was on that previous screen with the tiger, reflects some of the reasoning for the need for courtesy, stating that while the process is adversarial, it's not acceptable to let adversity become incivility. And I think that's really a good guiding principle, right? You can be adverse. We have to be adverse. It's an adverse system. That's our truth-finding process, right? But it doesn't mean that it's uncivil. It's a fine line. So the rule stipulates then that lawyers must discharge their duties in the adversarial process by fair and honorable means, without illegality, and in a manner that's consistent with the lawyer's duty to treat the tribunal with candor, fairness, courtesy, and respect. And it has to be done in a way that promotes the parties' rights to a fair hearing in which justice can be done and also seen to be done. And I think the seen to be done can be hard when it comes to civility because, you know, we've all seen the TV shows, we've all seen the movies, and we're influenced by that. Well, is a lawyer doing their job if they're not going for the jugular? I mean, you know, if you're getting along with the lawyer on the other side, how are you promoting my interests, right? How are you fighting for me? And it's really overcoming that specter, I think, that is a difficult thing for lawyers to do. Never mind on the layers of difficulty created by the pandemic, where people are really stressed right now and isolated. So I think when you start putting all those things together, it's really understandable why civility maybe isn't at its peak right now. But really the underlying principle is maintaining dignity, decorum, and courtesy in the courtroom, and that's not an empty formality. Rules 2.1-1 and 5.6-1 require that the lawyer discharge all of their responsibilities to clients, tribunals, and the public and other members of the profession honorably and with integrity. And that's to encourage public respect for and improve the administration of justice. So you've heard me say administration of justice a few times, and that really is that foundational principle, that it's so important. You know, it's not just a family file that's gone sideways. It's not just a client who's in custody. It's not just a deal where negotiations are breaking down. It's that underlying importance of what the justice system really is in this country. Civility is the foundation of those principles, and it's impossible to meet the obligations where the situation has deteriorated to the point where civility is gone. Like I say, I speak to lawyers who are beside themselves. I don't want to pick up that file. I don't want to pick up the phone. I don't know how to engage with this. What do I do? It's yes, you know, as lawyers, we're putting ourselves in the middle of disputes, right? But we shouldn't be creating conflict or having to subject ourselves to conflict or be abused, frankly, on a file. So ultimately, I think if you find that you're in a situation where you're being yelled at, or maybe you're, you know, so frustrated you've reached the point where you want to yell or are yelling, try to stop and see where things have gone sideways and try to step back and find a remedy if you can. Try to dial it back. Next slide, please, Glenn. I've talked about the American standards a little bit, and despite our differing foundations, our different terminology, American regulators are also remarking on the deterioration of civility over the past 2 years. And more, we are learning about the impact of stress on people and on lawyers as people, and trying to improve wellness for lawyers. Lack of civility has a tremendously negative impact on the lawyer on the other side of it. Dealing with that really difficult lawyer makes it hard to work on the file. It causes unnecessary stress, it drives up costs, and it can lead to errors on both sides. And, you know, I mean, I speak to this from experience. One of the worst files I had as a lawyer was somebody on the other side who was just bullying me and pushing me around, and I didn't want to pick up that file. I got to court, and you know, it impacts confidence, and then I feel, oh, am I compromising my client's interest? There has to be strategies to deal with that, and we'll come to that in a bit. The reality is, though, that only lawyers can solve this problem. We can't leave it to the courts. We can't leave it to the regulators. Each of us plays a key role. And I think ultimately the thing is that civility is about respect. Respect for clients, opposing lawyers, judges, justices, clerks, staff as human beings. And I think that the pandemic has removed that fundamental from so many of our interactions. We forget we're dealing with people. You may not like the opposing lawyer, you may not believe the opposing party, you may have reasons to question a judge's previous rulings, but none of this gives us the right to treat anybody badly or to be treated badly, right? It doesn't mean you have to take it either. And I'm also alive to the fact that often the bigger offenders aren't listening, or they don't see themselves in what you describe as being behavior that isn't civil. And I think the solution lies in raising the problem and raising it over and over, so that maybe somebody at some point will say, okay, yeah, maybe that is me, but also having strategies, as I've said, to try to deal with it. Next slide, please, Glenn. So this is some of what the practice advisors are seeing. And I can say, you know, we've gone from receiving, you know, fairly regular calls about civility being a problem to it being just something we are dealing with regularly. So speaking broadly, here's what we're seeing, where the opposing lawyer is just difficult to deal with, and the lawyer doesn't want to then pick up the file, doesn't want to look at it. It becomes that file on the edge of your desk where you kind of get that stress reaction every time you look at it and think about working on it. Personal insults. The personal insults between lawyers is frankly surprising. I'm stunned that, you know, we can look at the lawyer on the other side. These are colleagues, these are junior lawyers, these are, and speak to them the way they're being spoken to. And it's not just speaking to, it's filed affidavits containing personal attacks against the opposing lawyer. We've heard of multiple times where the opposing lawyer is yelling at the other lawyer. That lawyer is working from home, trying to balance childcare perhaps, and you know, their child is there, they're in a car, and the lawyer says to the other lawyer, look, I'm sorry, my child's in the car, please stop yelling. And they just persist and also issue threats as well, right? So, I mean, the harm then spills over. Using all caps in emails, this continues to be a problem. That's akin to yelling. And so even if it's done innocently, what you may not know is that it's being perceived as aggression on the other side. We continue to see junior lawyers and students being bullied by more senior lawyers, lawyers saying things like, in all my years of practice, I've never ever seen a lawyer do what you're doing. And of course, that's designed to get a result for your client, right? Intimidate the other lawyer into questioning their own confidence and questioning the steps that they're taking. Insisting on scheduling court matters despite knowing, or perhaps because they know, that the other lawyer isn't available. And I get it. I know it's difficult to get into court right now, but it's not making anything better to say, well, I'm going on this day, whether you're there or not. And then advising the court, gee, I don't know why they're not here, right? Because now that's misleading the court as well, which just compounds the problem. Next slide, please, Glenn. We're also seeing a lot of lawyers writing to the court, and I do want to take a few minutes to address this point in particular, because it's a considerable problem and it seems to be getting worse. Certainly in Alberta it is, and it's very much an offshoot of Civility. It's resulting in problems and fights between lawyers. So that's where the problems with Civility are arising, because, well, now there's distrust as well, right? So it seems perhaps like an expedient way of getting something done, writing to the court, getting a response, but it does result in protracted fighting between the lawyers. It can drive up expenses. And this has just become a way of doing things, but instead it should be the exception. The rule for all communications with the court is that notice must be given to the opposing party unless there's one of those valid exceptions. And those valid exceptions are, you think about an Anton Pillar order, for example, right? Where there's potential harm to your client if you give notice to the other side. The Alberta Court of Appeal recently noted recently, I said 2017, doesn't seem like it's been that long, but it's still fairly recent. Applications without notice, which were formerly in Alberta under the Alberta Rules of Court called ex parte applications, are extraordinary, since it's a fundamental principle that parties have a right to be heard before their rights are negatively affected. And in the Ruby decision, the Supreme Court of Canada noted that the circumstances in which a court will accept submissions ex parte are exceptional and limited to those situations in which the delay in notice would result in harm, or where there is a fear that the other party will act improperly or irrevocably if notice were given. And so think about the language the courts are using here: exceptional, rare, limited, harm. And so following that, a letter to the court where, if you're submitting an order for signature and not making any other comments, that's okay. But if you're looking to bolster your client's position, or you're looking to vary the order, or you don't like the terms of the order that the other side has drafted, and so you're sending it to the court now and you're saying, well, those terms are improper because of A, B, and C, well, now you're making submissions, and that is an ex parte appearance. So the letters to the court shouldn't contain any whiff of substantive submissions. If you feel like you need to write a letter to the court to straighten out an order or to address a situation that happened in a hearing, and it includes any information, I really encourage you to step back and make that objective evaluation of the letter and determine whether it's appropriate. Are you just seeking to have the court sign off on an order that the parties have agreed to and the clients or the lawyers have signed off on? Great, right? That's okay. But if you're looking to change something, or you're unhappy with the lawyer on the other side, then I think you're getting into some gray territory and maybe in the position of making an ex parte communication. And if you reach that point, then maybe it means sending the draft to the other lawyer and saying, look, we're not getting anywhere on signing this order. This is what I'm proposing to send to the court. Let me know what your thoughts are. And the other lawyer may come back and say, I don't want you to send that letter, in which case file an application. And I know it's not easy right now. I know the courts are backlogged and it's electronic and it's hard, but it's not worth sacrificing the obligations to the court and to the clients, which can devolve, right? and the ways we see it devolving are, the court signing off on orders, and then there has to be an appeal or a process to set aside. It really muddies the water. If you do think, no, it's absolutely appropriate that I write to the court in this case, treat it as an application, send your draft letter to the other side, say, please let me know your thoughts. I want to send this in, but I want to include your thoughts on it, and will do so. Have them write back, revise your letter, send them the revised letter, and then send it to the court with an indication that you've had the other side provide their input into it. That way, it's that balanced consideration from the court. Next slide, please, Glenn. Bullying and harassment have become a huge problem. Maybe it's less of a problem, we're just more aware of it. I don't know, but we are more aware of its impacts on people, and we know that there's really no room for it within our profession. Some of the tools which make it clear that bullying isn't acceptable are the code and the OH&S legislation. In most jurisdictions and federally, the legislation has been amended to include bullying as creating an unsafe workplace. And as I've mentioned already today, Rule 6.3, which is the bullying and harassment rule, or the harassment discrimination rule, is under consideration for amendment. We're 3 years into that process, but it is coming. And of course, the OH&S requires a safe workplace, and bullying is a way that a workplace can be made unsafe. While the code is a personal obligation on the lawyer. So if I'm bullying someone, that can be something that I could be cited for, reported for to the Law Society. It's also an obligation under OH&S, but under OH&S, this is how you address the workplace itself and the people who run the workplace. It's not just the individual lawyer partner who's doing the bullying and creating the unsafe workplace. It's the workplace, that the people who run it not stepping in to stop it. So there's different layers of obligations, not just on lawyers. Of course, OH&S applies to other workplaces too. So bullying, harassment, and discrimination are defined forms of incivility. All are reportable and might result in a citation, as well as civil or possibly even criminal liability. I have heard of a few cases where it's been reported to the Attorney General. Next slide, please, Glenn. This just, I added the slide this morning after I received an email from the American Bar Association. Last month, a story came out from the American Bar Association about a lawyer who posted a really negative statements on his social media account. The account identified him as a lawyer, it identified his firm, and he made disparaging comments about women. And during the protests about George Floyd's death, he made really offensive racist statements and comments. The regulator determined that the comments violated the oath he took when he became a lawyer. And of course, in that state, the regulator is the court. And so the court was particularly concerned about the statements he made about Mr. Floyd, which the court found were intended to incite intensified racial conflict, not only in the respondents' Facebook community, but also in the broader community of Charleston and beyond. And so the statements about Mr. Floyd were deemed grounds for discipline under the state rules, which codify the lawyer's oath. So in the same way that our code of conduct codifies the oath that we take when we become lawyers. And that the statements tended to bring the legal profession into disrepute. The court ordered a 6-month suspension and directed the lawyer to undergo diversity training and also assessments by a licensed mental health professional. It also ordered him to comply with all recommended treatments and provided regular treatment reports and affidavits of compliance. So a fairly stringent and hopefully effective penalty against this lawyer. But, discrimination, harassment, bullying, these are areas where there's less of a clear line between a personal life and a professional life. And so conduct that's happening in the personal life can be deemed citable conduct for a lawyer. One comment in the story that I read this morning was that the comments demeaned the profession, and as a result of demeaning the profession, should be disciplined. So of course, that's again that, the importance of the administration of justice as a very public principle. Next slide, please, Glenn. So just very generally speaking, lawyers must not mislead the court, can't cast aspersions, must not cast aspersions on the other party or witness, unless there's, if you have sufficient basis, if you know, right, like you've done your investigation, you have sworn testimony, you've got the evidence. This isn't saying, again, go back to being the lamb or the lion. This isn't saying be the lamb and don't advance any issues that are legitimately borne out. It's the aspersions that aren't borne out, where it's, maybe frustration or maybe a strategy to attack the other lawyer or attack the witness. Those are the areas where it's problematic. Next slide, please, Glenn. I mentioned earlier a case in Alberta that surprised me in the outcome. This is a written decision. One lawyer was calling the other names. Parasite is the one that comes to mind in written communications, foul language being used in the communications. The court held that this was a case of sharp practice and worthy of sanction with elevated costs, but not costs payable by the lawyer, which I found interesting because this is, the client paying the penalty for the lawyer's conduct. And maybe there was more to the file that was apparent from the hearing that isn't apparent from the written decision. But I did think that was surprising. And then at the end, the master made a comment where he expressed his very strong disapproval of the language used by the plaintiff's lawyer. So it's, not a reprimand, but certainly I wouldn't want to be the lawyer and knowing that this was my reputation, right? The reputational risk now to these kinds of communication is considerable. Next slide, please, Glenn. Rule 3.4-1, commentary 12 considers the different supervisory rules of the court versus the regulator. Of course, the courts have jurisdiction to supervise court proceedings, and in doing so, they apply fiduciary principles developed by the courts to supervise lawyers' relationships with clients. And they do so to ensure the proper administration of justice. There it is again, right? A breach of the code can lead to sanction by the regulator, even where a court dealing with the same rules may decline to make an order. And this was very much the situation in Mr. Groya's case. He made submissions. The court really didn't change course on that, didn't raise it as a problem, but the Law Society did see it as a problem and cited Mr. Groya and proceeded on those citations and ultimately sanctions as well. So the two processes are different. Lawyers will call me and say, look, this lawyer is doing this and this and this. Should I report them? Because I really need this and this to happen on my file. The Law Society doesn't grant civil relief. It regulates lawyer conduct in the interest of the public. And so if you're looking to report a lawyer to get them to stop doing what they're doing or to do something else, maybe a report will have that impact, but that isn't the Law Society's function. Next slide, please. So I've said at a couple of points in the presentation, it's really lies on us as lawyers. How do you address somebody who's treating you with a lack of civility? Ultimately, the best management of conflict involves what the individual lawyer can do themselves, recognizing you can't control the client, you can't control the court. Lawyer job satisfaction is enhanced by positive client relationships and building good relationships with colleagues in and outside of the office, which of course is really difficult right now, and by having strategies to manage conflict. One of the strategies we would use at my firm was, and this was an unofficial policy, but it worked really well. If I had a file that had become a problem and the other lawyer was aggressive and attacking me personally, or perhaps I had a poor connection with the client and so the relationship was devolving there, we could trade it. We had this policy. I could walk into one of my colleagues' offices and say, I can't anymore. Please, will you take this? I will take one of your difficult files in return. And we would manage so that, the billings were fair to the clients, that they weren't being billed for us getting up to speed on the file. But I often found that the lawyer that was the file that was given to me in advance, it was fine. I didn't have the same problems that were happening between my colleague and the opposing lawyer, or my colleague and the client, and I could pick up the file and carry on. So it made my life better, and it made the other lawyers better, and probably made the situation better for the clients as well. So that's certainly one strategy to consider. Self-care, I can't emphasize that enough. Wellness has become such a key point for lawyers right now, but just recognizing when you're being attacked, recognizing that you don't have to deal with that. And lawyers will call us and say, you know, I'm being attacked by the other lawyer. I think I'm getting in the way of the client's interests being advanced. And maybe you don't have a firm or another lawyer who you can trade files with. What do? I think in that case, you really have a meaningful conversation with your client about what the situation is, how you feel that maybe, you know, if you weren't on the file, that the situation would be better for the client. There are very few files where, as the lawyer on the file, you're the only one who could act. Another lawyer could come in, talk to the client about withdrawing, and having that other lawyer come in, help the client, you know, transition the file to a new lawyer, and just making it a better situation for yourself, for the client, and possibly even for the lawyer on the other side. I mean, maybe not. Maybe they'll continue being in civil, but it's that's just something you can't control. One article that I read recently about a senior lawyer who was dealing with a lack of civility, he took that strategy of deliberately keeping himself out of the conflict. And I think what I mean by that is he took his ego out of it, that the other lawyer could attack him and he would just say, you know, whatever, like, this isn't, you can attack me, but ultimately I need to do X, Y, and Z to advance my client's case. And I'm going to persist in doing that. And, you know, I'm just going to sort of take it on the chin, but whatever, you can call me whatever name you want. I'm not going to, as a result, dig into an unreasonable position. I can still recognize my client's interests and recognize that if I, you know, take a left turn here because I'm being attacked personally, that doesn't help the client. Fine, whatever. I think that's admirable, but incredibly difficult. If you can do it, great. If you can't, then I think finding another strategy. Next slide, please, Glenn. Here are some of the impacts that we see of incivility: increased fees, file delay. The lack of objectivity is big, right? Like, how do you advise a client on what they should be doing when you're so mad at the lawyer on the other side, or the client on the other side, or the self-represented party on the other side, where you're so mad that you see red when you pick up that file? And I mean, maybe you get into a mindset of, well, you know, I'll show you. You've lost your objectivity in that case. And maybe you need to look at whether that is a situation where you do need to withdraw. Stress, reticence to pick up that file. I told you about my experience on a file. I did not want to pick up that file. I mean, ultimately I did, of course, pick it up. But having to deal with that, and then, as I said, lawyer wellness, right? It wasn't a great situation for me. It wasn't a great situation for my client, and I'm sure the lawyer on the other side as well. But the stress leads you to make mistakes. And so if you continue, you might find that your next call is to your insurer, or maybe it's even where you're having to sue your client because the client doesn't want to pay for your fees because, you know, a finding came out against you and the client perceives it as being a result of the incivility. So I think the message here is you don't have to put up with it. You shouldn't put up with it, and it can lead to mistakes. So find that strategy. And sometimes the strategy is calling the practice advisors and talking it through with us, and we can help find some ways that you can release the pressure and find a way through for your client. Next slide, please, Glenn. I'll end with this, which is competence. I think that if you experience a visceral reaction, such as deep-seated dread, or maybe fire-like ire when you receive communications on a file and it's provoked by either the client or the opposing lawyer or the self-represented party on a particular file, I really think you need to do that assessment of, am I competent to act on this? Those kinds of responses can indicate that you're in a situation, and there's no blame here. If you're being attacked, of course you're taking it personally. But if you're taking it personally, you really have to consider whether you're changing your focus from the merits or the client's needs. Rule 3.4-12 commentary paragraph 2 suggests that this personal conflict impairs the lawyer's objectivity and requires withdrawal unless the client consents. So that's, again, having that meaningful conversation with your client to say, this is what I'm dealing with, this is what I'm thinking, what do you think, what's your input? Sometimes, as I said, reporting the opposing lawyer is the appropriate route. Sometimes reporting the other lawyer can prejudice the client. And so you have to really consider that route in the context of the file. And as I said earlier, because the Law Society doesn't grant civil relief, even reporting may not fix the problem. And in fact, it might make it worse. Next slide, please, Glenn. So that's the substance of what I have for you today. I'm happy to answer questions. As I said, Calvin and Hobbes was very much informing my thought process as I was preparing the slides. No trick questions. And then next slide, please, Glenn. There's our contacts. We do have a toll-free number, and also you can submit to contact us by email. We're always happy to hear from you. We're happy to help. So many people will say to me, I'm really sorry to be calling you. I'm sorry to bother you. You're not bothering us. This is what we do. We're happy to be here. We're happy to try to head off problems before they happen. Thank you.
Thanks very much, Beth. There was a question that came in, and I'm going to try and paraphrase it a little bit. You said at one point that we have a responsibility to the justice system. And the question is, do we have a responsibility to the justice system, or do we have a responsibility to the administration of justice? And are those two different things? And is this a difference that's it's emphasized or exacerbated or made more prevalent now, particularly in a time of increased awareness of reconciliation? Are you able to comment on that?
I'm going to ask you to repeat the second part, but in terms of the justice system and the administration of justice, I think even if they're different, well, they are different, right? We do have, I think that the justice system is the players within the system. That's the lawyers, the clients, the judges themselves. We have obligations to each of those entities or parties or individuals, but I think we also do have an obligation to the administration of justice, and that's that broader, I don't want to say aspirational principle, but it is one of those foundational principles that, like, that's everything that our system rests on, is the administration of justice. Sorry, Glenn, can you please repeat the second part?
Sure. The second part is that distinction magnified as we enter into, or out, because we're in an area with it, we're in increased awareness of reconciliation. Does reconciliation impact on that?
Yeah, I think it does. I think, maybe this is a little bit of an aside, but, of course, there's the factors within criminal context to evaluate a client's concerns. And of course, the name of the case should not have slipped me, but it has slipped me. I think that evaluation needs to be done in all cases, not just in criminal cases, where we're working with Indigenous clients, Indigenous parties are impacted. Yes, I think that's very much a part of both the justice system, because often Indigenous people are overrepresented in different areas, of course, criminal law and child welfare, but also in the administration of justice. Sorry, I got that backwards. In both the administration of justice, they are overrepresented, but I think we have obligations in the administration of justice and with our obligations to be sure that we're meeting those obligations. And if it's if the civility has disintegrated on a matter maybe involving child welfare, I think that's something the lawyers need to be keenly aware of and really address, because the clients are so much more vulnerable even than a run-of-the-mill client, if I can use that term.
Great, thanks, Beth. Another question, and we've seen this a couple of times, and someone else in the group has posed it. How, and this may be an unanswerable question, but how do you deal with a non-lawyer on the other side who's being absolutely uncivil, a self-rep who's being completely uncivil?
A couple of things. This isn't easy. I mean, I think there's a few strategies you can use. Certainly call the practice advisors and talk to us, because sometimes just talking about it helps. And we're happy to be sort of that release valve. But it depends on what that self-represented party is doing. If they're inundating you with emails, for example, and we see that a lot, and so you can't even get any work done because you're getting 50, 60 emails a day, I recommend setting a tool up on your email, talk to your IT people, so that those emails go directly into a folder. So now they're not at least disrupting your workflow. You can go in and check that folder at the end of your workday, maybe, when it's not going to derail everything else you're trying to work on. I often will recommend going to the court and getting advice and direction on dealing with those communications, dealing with that person. And that has a couple of benefits. One is you can indicate, look, I'm only going to respond on Thursdays or Friday mornings, perhaps. And so that indicates to the self-rep that you're not going to be triggered by these emails, by these communications. So you have some control over it, but it also protects you in terms of if they send something that says, well, this needs an answer right now, you've got the court's blessing to say, no, you're only responding once a week. And while you could say to that self-represented party, look, I'm only reviewing those emails once a week and I'll respond on Friday mornings, what I do recommend is you do actually go in and just monitor, or have your assistant or a paralegal, somebody else go in and monitor to say, oh, look, they've sent this email, they've brought an emergency application, you need to respond to this, so that you can create some distance between yourself and those triggering communications. But I really, when it gets bad, enlist the assistance of the court and the process. You don't have to put up with that. Nothing about when we became lawyers was, I will subject myself to abuse by somebody who is just not in a really good place right now. The other benefit to seeking advice and direction is if you need to get to the place of seeking a vexatious litigant declaration, you've started that process, right? It's not just sort of a, oh my gosh, I've reached the end, I can't cope with this anymore, and now I'm trying to paper it with the court. You've already started down that road, so it should be a little bit easier as you get there. The other thing I'd recommend is, and I don't know what the organization is in the Northwest Territories, I apologize. In Alberta, we have Assist, but just somewhere where you can speak to somebody and get that out of your space. I remember working with a lawyer who said, I don't want to take this home with me at the end of the day. I want to have somebody I can speak to about it who's confidential. So I'm not going home to my husband and child and I'm full of this anxiety and angst and anger and taking it home and having it impact my home. And so again, sort of self-care. Those are some of the strategies, but certainly give us a call.
Great, thanks for that, Beth. And the NWT version of Assist is Homewood, and you can access that through the website. You'll see it mentioned in the newsletters that we send out as well, so that they're equally available to you. All right, there are no other questions. So maybe just if you could spare just a couple more minutes, Beth. I wanted to remind everybody that Beth and the people in her office are the practice advisors for the Law Society of Alberta, but they also provide assistance to us. So by all means, make use of them. They're a tremendous resource, and they will give you great advice all the time. And they promise, I think, Beth, you promise to get back to people within 1 day, right? If that's the longest you say it will take.
We try. We've had to change that to 2. We are receiving right now, there's 3 of us. and we are receiving more than 6,000 calls a year right now. So we try for 1 day, but we've now stipulated 2. If it's something urgent, we will get back to you within 24 hours. So you just indicate in your message, this is urgent, and that then pulls it to the front of the line.
Great. All right. And one other reminder that's completely unrelated to this, it's the renewal season, and those of you that haven't gotten around to doing it, and there's about 200 of you, you might want to do that between now and next Thursday, because we're not real keen on suspending people, and that's the other alternative. Any other questions? Doesn't seem so. All right. Then, Beth, I'd like to thank you. Thank you for all the work you do on an ongoing basis, and thank you for agreeing each year to put this on. And perhaps next year we can get back to doing this in person, and let's hope so.
I hope so. Thanks very much for asking me. And yes, please do reach out to us. We're always happy to speak to lawyers from other jurisdictions too. So, yeah.
All right. Thanks, everybody. Enjoy your afternoon.